For the final segment, a number of you were asking, when are these people going to be on stage? And they are coming on stage now. As entrepreneurs, we have many questions pertaining to legal framework. We want to get it right, but often have little or no guidance whatsoever. Please welcome Ronnie and Adnan to guide us when it comes to right legal framework for accelerating growth.
Thank you. Thank you very much for the kind introduction. And whoever's left in the room, thank you very much for staying. It's a tough act to follow, the entrepreneurs, but we'll do our best to keep it interesting for you. So I'll turn it over to you.
So first of all, thanks for the event organizers for giving us the opportunity to speak today. Our session is entitled Fireside Chat, Building the Right Legal Framework to Catapult Your Business to the Next Level. The irony of the fact that I lived in England for many years, but had to come to Dubai, where it's 28 degrees outside for my first fireside chat, is not lost on me. But be that as it may, I think the objective of this session is just to recognize that a number of you have reached a certain stage with your development of your business, and how can lawyers effectively help to take you to that next stage of development.
So this is an overview of what we'll be discussing today. Basically some just broad topics about growth and, now that you're here, what do you do next? And I think, as a corporate lawyer, probably the first thing we tend to look at, when we're asked questions about investments and fundraising and whatnot is, having an examination of the overall corporate structure of the business to ensure that it is serving the business and the future objective of the business properly. And so in Dubai, we usually touch upon the same themes over and over. Is my business established properly? Should I be onshore? Should I be in a free zone? What are the benefits to each? We have questions about ring fencing liabilities in terms of the various business units or kind of verticals within the business. And then we have basically issues around ease of investment, and you find this the most when you talk, when you're considering companies set up onshore, and basically the various ownership requirements that onshore companies face, and in addition to the kind of inflexibility as to what you could do with the capital structure. And then there's also the consideration of the regulatory requirements when considering where you're going to set up in Dubai. So, taking it in turn, one by one, touching upon these points, you obviously have upside and, potentially a little bit of downside when you're deciding whether to set up onshore versus a free zone. We all know that the free zones give you the flexibility of having complete ownership over your business, but at the same time, there are limitations as to how you could carry out that business in the broader UAE. Onshore, on the other hand, there is the local ownership requirement, which means that you could only, on paper, ever own 49% of your business legally. And down the line, when you are seeking investment, that could have a slew of issues associated with it, including getting your investors comfortable with the arrangements that we're going to talk about a little down the line here, of how you get comfort around your beneficial ownership of the business. Ease of investment, again, that's another topic. How do your investors come in? With the free zones, if you're set up in the right free zone, if there's flexibility around the share capital, they could come in directly. When you're onshore, there is some structuring that has to be done around that, potentially interjecting a holdco to hold the 49% interest so that you could facilitate investments for your investor. And then there's, basically the regulatory requirements. In the free zones, they probably have certain entities that allow for more flexibility when it comes to matters of corporate governance and whatnot. Ensuring that things are documented properly, requirements for AGM, and so on and so forth. Certain entities within the free zone, like the FZ LLC, for example, may give you some flexibility in relation to those requirements, but you may not find that so much onshore. And then we come to the next big issue for the onshore ownership, which is the local sponsors. And you know, this is a big one, and especially we see it for SME clients. You know, business starts, it's growing, and then all of a sudden you start having these issues with your local sponsor because you're becoming more profitable, and they feel that potentially the fee, you know, that they were getting in the past, you know, is not sufficient for what the business is doing now and the inherent liability associated with their role. And so at that point in time, you have to consider whether or not you want to go the route of having a professional sponsor in place and basically ensuring that the arrangements with your local sponsor are you know, fit to protect the business to the extent possible, you know, against any kind of infraction or kind of an undue involvement by the local sponsor. So I think that takes us to the next slide.
Thanks, Ronnie. So having said all that in relation to local sponsors and local ownership, towards the end of last year, I think it's 23rd or 24th of September, was introduced the UAE Foreign Direct Investment Law. Now that had and continues, I think, to have the potential for a seismic shift in terms of how people do business, foreign investors do business in this part of the world. Essentially what it does is it creates a framework for more than the 49% and up to 100% foreign ownership under certain circumstances and in certain sectors. So the way the law is structured is to create essentially a negative list of sectors which remain kind of protectionist areas where there will not be any relaxation of the local ownership requirement, and a positive list of sectors where that relaxation will be permitted under certain circumstances. Slightly unhelpfully, we're still operating in the area whereby we don't have that populated positive list of sectors. So, you know, we're still looking out for that, but I think we get a sense based on the law that the sectors themselves will be ones that rely heavily on technology, innovation, those things that essentially the powers that be are pushing to try and encourage people to come in and operate in this part of the world. We, Taylor Wessing, have some experience with one of our clients specifically in setting up an onshore LLC 100% owned pursuant to the UAE FDI laws. So what I can tell you is that the Foreign Direct Investment Unit, which is a unit underneath the Ministry of Economy, they're pretty collaborative when it comes down to this particular structure. So if you engage with them early and engage with them, you know, frequently in a fairly transparent manner, I think you know, one will find that it's very helpful in terms of a process. The next issue is on trade licenses. So I think a lot of you will agree that businesses evolve. So from the point in time at which the business has been incorporated to the point in time when you're looking to seek new investment or move to the next phase of your business cycle, it's entirely possible, and in fact probable, that what you're doing now is different to what you were doing when you first started off. So what we recommend generally is that, you know, some sort of health check in terms of the activities that you're doing to ensure that the scope of those activities remain firmly within the ambit of what you're regulated to do, essentially. Now, that's not something that needs to be done, you know, on a weekly or a monthly basis, but it's definitely something that should be done before you get to the stage when you're seeking new investment and or trying to effectively launch a new product line or service line. And the point on special approvals is the same. So depending on, you know, how vanilla your business used to be and how more specific it might be based on the next phase, you're likely to need certain special approvals from various different regulatory bodies. So it's just something to be aware of, if not overly concerned with. Ronnie, next one. So in terms of growth, obviously there's organic growth, which is, you know, one that relies on your own positive performance and cash flow and everything else. But I think what we're talking about on this slide is when you get to the next stage, or you're looking to seek to get to the next stage of your development, more transformative growth can happen more quickly through M&A or strategic joint ventures. Now, each of those topics are, you know, detailed enough that they could form the basis of their own presentation. So we're not going to, by any means, touch on every aspect that you need to be considering when adopting these methods of growth, but just a few things to kind of be conscious of. In terms of M&A, when you're looking to make that strategic acquisition, obviously due diligence is key, and that's not just legal due diligence, the likes that we get involved with, but commercial due diligence and financial due diligence as well. My recommendation would always be to hire professionals to assist with that work stream. But a cautionary bit of advice is, in my experience, more money has been wasted by clients, not mine, of course, but other clients, on the due diligence phase of a transaction. Because you get to a stage where actually there's no such thing as too much due diligence on that which you're seeking to acquire, but you need to recognize that at a certain point, once you have a good lay of the land as to what it is that you're looking to acquire and what the pitfalls are associated with it, there are probably diminishing returns to continuing to do more and more diligence at that stage, because nothing's going to change the nature of what it is you're acquiring. You do the diligence up to a certain point, you mitigate those risks as best you can, and then you take a decision commercially as to whether or not it's the right thing for you to do. Valuation, obviously key when you're looking to acquire something. It sounds like a very obvious point, but again, to the extent that you can hire professionals to help you with valuation, that's a good thing to focus on, because it can be tempting, I think, when you're too close to that which you're acquiring, to sort of ascribe more value to something that perhaps it actually deserves. So it's important to be objective when you're talking about valuation. Typically, there are a number of ways to value an asset. The most common that I've sort of seen in my career is some sort of EBITDA multiple. But again, you need to be cautious with that, because there's no science behind that multiple. In my experience, it tends to be, objective analysis of what it is that you're buying, often from different parties, leads to very different multiples in terms of the EBITDA multiple for an acquisition. So just take a step back, be conscious of what it is that you're valuing, the basis on which that valuation is taking place. In terms of consideration, that's dealing with the form and the structure of what you're paying to acquire what it is that you're acquiring. Obviously, that's a combination of cash, debt, maybe some sort of share-for-share equity exchange, etc. And then the other thing to be conscious of is to what extent you're able to link that consideration to the ongoing performance of the target entity. So, and you can do that in a few ways. You can do it by linking consideration to performance in the form of an earnout. You can defer the consideration subject to certain other objective conditions and criteria. On joint ventures, that's obviously a very exciting phase to get to with an SME. So you've seen an opportunity, you don't think you can necessarily service it yourself, and you see someone with whom, or another entity with whom you have some sort of synergy, but at the same time each of you is bringing something different to a particular set of operations. I think the key thing in that situation is to ensure that you're clear from the outset as to what the different roles and responsibilities and duties those two parties or three parties are in that joint venture. Each party will have strengths and key things that they're contributing to a joint venture, otherwise you wouldn't necessarily be doing it. But you don't want to get to a situation down the line where you haven't articulated clearly enough and regularly enough what it is that each person's meant to be doing. So you end up with a kind of a situation of inertia where the new joint venture is not really taking off in the way that you initially envisaged that it would. Decision-making control, it kind of comes to a similar point. You want to ensure that you aren't over-engineering a situation when it comes down to decision-making control. Oftentimes, in our experience, a lot of negotiations done in relation to reserve matters and which things need to be approved by which committees and which things need to be approved by which shareholders and signed off in respect to particular materiality thresholds, etc. I think you don't want to lose sight of the fact that essentially this is a business that needs to operate. So vest that control in a set of directors that each of the shareholders has a certain amount of say in appointing and also is provided information by, and then try to limit your reserve matters that involve the shareholders or others coming in to take control of the business in relation to specific areas to those things which really go to value, because otherwise what you're doing is you're creating a slightly cumbersome creature that may look good on paper but doesn't actually operate in the way that you'd like it to in an efficient manner. Share transfers and exits. So although, these are things to think about when you're going in, obviously you should have one eye on the future as well, and that's, exit in terms of what you see being the exit plan for this business, the time frame, and the manner in which that will kind of monetize itself. And in terms of share transfers, these are obviously hotly contested. There's periods during which no one should be allowed to sell their shares other than to certain specified permitted transferees, the so-called lock-in period. The rationale behind that is that, people are obviously coming together with particular vision, and that vision is going to take some time to implement. So you want to make sure that everyone has a decent run at that, making that venture a success before anyone can divest to someone else. There are other controls and protections that you can put in place to ensure that that takes place. So if you've done a lot of upfront due diligence and investigation with your counterparty for the joint venture, and you're doing that joint venture because, subject to other things you've discussed, you each have something that you can uniquely bring to the table, and you're comfortable with each other and how you want to do business. So you don't want to be in a situation where one of those shareholders divests down to a minimal level very quickly, or indeed sells out to someone else that you don't necessarily have that same familiarity with or shared vision. So there are protections to ensure that doesn't take place. Deadlock resolution. So again, going back to a theme I mentioned earlier in terms of trying to make sure this joint venture is not too unwieldy or burdensome. You can get very fixated, I think, or lawyers can specifically, on lots of very involved and funky ways to resolve deadlocks when it comes down to operating a company like this, including multiple put options, call options, roulette that requires you to make a buyout option for the other counterparty, and even culminating in liquidation of the entity. I think it's important to ensure that whatever a deadlock resolution mechanism you adopt in the context of your joint venture, you have a strong business plan or other document that both parties are aligned on when you go in. And you can say that to the extent that there is a deadlock that manifests itself at some point during the process, that doesn't bring the company to its knees while you're trying to resolve that deadlock, because that's no good to anyone. You need to ensure that you can maintain that company operating in the status quo whilst that deadlock is ongoing, so that it doesn't cripple the company, essentially.
So I'm sure this next topic is one that probably keeps many of the proprietors of SMEs up at night, and it's what to do in a situation where the business has immediate cash requirements, and in some instances how you approach this issue is already dictated for you. If you're in a life cycle in your business where you already have your investors, you've already worked out your various agreements with them, and there is a provision that talks about the order of how you go about getting your funding, then you're basically locked to that order. But in some other situations, you may be earlier on in the life cycle of your business, and you have some more flexibility as to which path of fundraising to produce. And they broadly fall under three types of funding. Three types of categories that you could pursue to secure additional funding. And so the first, and I think the one that most people in this room would be very familiar with, is the equity financing. Basically issuing shares for additional money. If your business is more advanced in its life cycle and there's restrictions around this in your investment documentation, this may be something that you can't do immediately, but have to go through a process to do. However, if you do have that flexibility, then the decision is, basically how you go about in structuring that. Do you give the people coming on control rights, full control rights and economic rights, for the money that they're injecting into your business, or do you limit those rights, by using preference shares, to ensure that you have in the short term the control that you need, but they get an economic uplift in the long term, as in when certain events happen. You also have debt finance. You're going through the process of obtaining a loan, going to your banks, going to your financiers, getting a loan, ensuring that that's on competitive terms and competitive rates. And then basically you always have the option of the convertibles, and we're seeing more and more of this, and especially in a kind of early stage growth business, this could be a very popular option. Your convertible loan agreement, or in some instances the sale of future equity agreement, whereby you're basically taking on the investment initially as a loan, and then if certain milestones are met, you have situations where that loan can convert either automatically or by consent of your investor into share capital in the company. Okay. And then basically the management, employees, and incentivization. I think this was a theme touched upon in the last panel discussion, because there was a lot of highlight about your people, the people around you, and treating those people well. And it's something that I think maybe overlooked in the short term, maybe an area that SMEs and entrepreneurs, they don't have enough time to look at it properly, but definitely this is an area where I think in the long term, it really pays off for a little bit of investment, earlier on. And so talk about basically your managers, your directors, ensuring that you have proper arrangements in place with them, ensuring that they're aware of their statutory and fiduciary obligations to the company, and ensuring that you have the proper insurance in place to cover them if anything goes wrong, because if you have a multitude of investors, that scenario is not as easy to control as a scenario where you have very limited shareholders and you have to basically deal with the directors on a more limited basis. You have the service contracts with these directors or potentially executive directors, making sure that their responsibilities are properly provided for, in-depth provisions in relation to their remuneration and allowance, making sure that those are very clear so that there's no disagreement in the future about things like deferred compensation or bonus-based compensation. The termination provisions, it's not a scenario that people like to discuss, but it's something that needs to be legislated for very diligently in your agreements, and then having a think about the value that they add and what kind of harm they could do if they do leave your business, and making sure that you have the restrictions in place to safeguard the interests of the business. And then your employees, rewarding those people that started the journey with you, how you go about doing that. I know Idris mentioned, that equity, be generous with the equity, give it away early and so on and so forth. And, while that is always an option, I think there are other considerations. Giving away equity and, playing too much with the capital structure of the company and the control rights associated with it may not be, in the short term, the best approach. You have various options for basically, share incentivization schemes, bonuses, LTIPs, basically plans where phantom shares are awarded that don't have the economic and control rights associated with them. So, keeping your eye out on whether or not you are giving away too much equity too early on, and finding a way to structure around that for SMEs, I think, is a very important concern.
Yeah, thanks, Ronnie. So commercial contracts, one very important thing I think to be aware of and on top of when it comes down to getting to the next stage of your development are your commercial contracts. Because I think a number of SMEs will, at a specific point in their development, operate in a slightly more informal way. And I think that's not a criticism, that's just a fact. But you need to, I think, when you're moving to the next stage, formalize those kind of operational agreements and make sure that what you have is sufficiently legally robust to be able to stand scrutiny both from counterparties and potential investors. So specific areas of concern, I think, or not concern, but certainly of importance are indemnities. So there'll often be a temptation to ensure that each of your contracts has as broad-based an indemnity to protect you from pretty much anything as possible. And while that is good from a legal perspective, it's a commercial contract, so it needs to be commercial in the sense that counterparties will not simply accept blanket indemnities in relation to any possible risk that you're looking to cover yourself against. So, be specific is the key. Be specific. Be focused in terms of those things that you're seeking to genuinely protect yourself from, and focus on that. Termination. Assuming one doesn't have a termination for convenience provision in there, which obviously would be great if that's what you want, it's important to set out the specific circumstances that can lead to a termination and under what circumstances one party can terminate versus the other, for example. And I think just as important as what leads to a termination is what should happen in terms of rights and obligations to the parties following termination. So more often than not, when you're operating in a commercial environment, you can't just upon termination of a contract just both walk away and not necessarily have to deal with it over again. More often than not, you need to kind of recognize that certain things have been done that can't necessarily be reversed, and therefore, how does one treat those? Can you hear me? Yeah. Non-compete, I think that's important, but I think many of you will be aware that non-competes are particularly difficult to enforce. So again, the key here is precision in order to mitigate that risk of enforceability, precision and being specific, ensuring that your non-compete focuses on a specific area of operations, a specific territory, and for a feasible, reasonable period of time. So, tempting though it may be to put in non-compete provisions that cover any and all things that the company does everywhere in the world in perpetuity, that's not our advice in terms of going down that route. And dispute resolution, again, I mean, I touched on this theme earlier before. You don't want to focus unduly on dispute resolution, but it's something that needs to be robustly handled in your commercial contracts. And I think the thing to think about is the content of that contract will, to a large extent, determine what the most appropriate forum for dispute resolution is. So it may be that certain types of commercial contracts require, a more convoluted, tiered approach to dispute resolution, which involves, objective parties on both sides meeting to discuss the problem, trying to find a solution, followed by a formal mediation process, and then finally culminating in arbitration. Whereas there might be other commercial contracts whose content are sufficiently simple that you're happy to go with a more straight to a court, get the order, and move on that basis. So it's sort of horses for courses when it comes down to the nature of the commercial contract.
And finally, intellectual property and data protection is, especially with the amount of the tech-based SMEs that we're seeing and where they are in their growth cycle. These are issues that are becoming more and more important for these types of businesses. And there's always a concern about protecting your intellectual property and how you go about doing that. Basically, the types of IP that are being used in the business very much dictates how you would go about protecting the intellectual property of the business. If you have software and source code and things of that nature, you could go down the path of copyright and various other protections that could be available to you. And if you have kind of more nebulous IP, like something that can't necessarily be protected through copyright or any kind of registration, basically how you go about ring fencing that and ensuring that it's protected, your know-how, your processes and procedures and trade secrets and whatnot. You also have the issue of your brand, your trademarks. We get a lot of questions about that and basically the extent of protection that should be attributed to that. And I think a key issue is do you go about investing a lot of time and effort in ensuring your trademark and your brand is as broadly protected as it could possibly be, the global protection, or do you basically focus on the markets that you operate? So that's always an analysis that a lot of SMEs are concerned about, especially in their growth trajectory. And then finally, there's the issue of structuring IP. As your business grows and it develops and it becomes more complicated, there's always an issue as to how this IP is held and then used throughout the business. At a certain point in time, your business may comprise of several entities that are all using maybe all of the IP or a portion of the IP. And then at that point, thinking about how to structure that, whether you have a holding company that ring fences all of your IPs, that then sublicense the IP to the various affiliates, is something that you have to think about and consider. And then data, this is becoming another very hot issue for businesses that have a lot of online customers or customer databases, basically, how you properly use that data. If for example, in Europe, the new data regulations just came out and they're very broad and extensive and their reach is very broad and extensive. Making sure that you conduct that health check to ensure that you're treating, data for customers that may touch upon that regulation, is a worthwhile investment because, as we know now, the fine imposition and the various negative sanctions associated with these kind of breaches, could be significant. And it could be something that could stifle, depending on where you are in your growth trajectory, your business facing too many of these issues. So I think that takes us through the presentation. Those are basically some key topics that we thought about, from the SME perspective, that repeated themes that repeatedly come up from our clients in terms of how to handle them and what considerations need to be made in dealing with them. We have, I think, some time left for some questions, if anyone has any questions. It's very interesting stuff, the legal side of things.
Otherwise, thanks very much for your patience. I hope that you found it useful. Thanks very much, guys.
Thank you.